Hello, this is Don Swanson. I'm here today with Judge Lou Kornreich. Our topic of discussion is the relative merits of uh, two types of mediators. One is a private practice mediator, and the other is a judicial mediator or sitting judge as mediator. This is a bit of a controversy every now and then, and Judge Kornreich is particularly well qualified to address this subject because he has a long and distinguished career as both a bankruptcy judge and as a private practice mediator. So welcome, Judge.
Well, thank you very much, Don, and it's a great honor to be with you this morning.
Well, thank you. Why don't we start by hearing from you a little bit on your background in these two areas, as a judge and as a private practice mediator?
Thank you. It's actually the 20th anniversary this week of my becoming a judge, and I've been off the bench now for 6 years. So um, uh, my judicial experience is still recent enough that I can remember it even at my age. And my non-judicial mediation experience is very, very current. But I'd like to begin before that. Um, I started practicing law in the mid 1970s. And it had always been my project, if you will, to moderate my ethical duties to the client as being a tough adversary and a tough advocate um, in a way that would allow the client to understand the other side. So my interest in conciliation goes all the way back to the practice of law for about 30 years and has always been a goal of mine, even when I was not actively a mediator. I thought that negotiated settlements, particularly in the commercial field and in the bankruptcy field, were always better than judgments, and tried to work with my own side and with opponents to arrive at a resolution that everyone could buy into. So the notion of conciliation and mediation is not limited to my mediation practice as a judge or my mediation practice now. It began a long time ago. Now, on the bench, one of my colleagues used to say that he was hired by the government to render judgment, not not to make compromises, and that his time was better spent preparing for and sitting on trials and adjudicating disputes. I always disagreed with that premise. I thought we were in the business of conflict resolution, and whether mediation is ADR or litigation is ADR, I don't know. But I think they're all forms, alternative forms of dispute resolution. And a presiding judge has a lot of power. Sometimes it can be abused, but sometimes it can be used to bring parties together. You know, there's a popular television show that's been around for a long, long time. It's called Law and Order. And people often say to me, is there anything accurate in that show? And I say there's 1 minute in every hour-long episode that's very accurate. And that's when the judge says, in my chambers, now. And that 1 minute chambers conversation is usually very accurate. And the timeline is very accurate because usually it only takes a minute. And so the idea of in my chambers was always something that was on my mind, because if I saw things going awry, whether it was at a conference, whether it was at a hearing on a motion, or whether it was in the middle of a trial, I had no reservation about bringing counsel into chambers, and sometimes with clients, to not to rebuke necessarily, but just to air the notion that maybe there's a different direction we might be able to go to assist in the final resolution of this case. Now, that's not for everyone. It's not for every judge. It's not for every party. And many, if not most judges, prefer to do everything on the record all the time. And there are good reasons for that, and we understand those reasons. We don't have to dwell on them today. But my approach was deviant. I concede that, and I think in the long run, perhaps beneficial. As a judge, I tried to introduce mediation into our district, both at the bankruptcy level and at the district court level, and was able to prevail upon my colleagues on the bankruptcy bench, on the magistrate bench, and on the district court bench to use one another to help resolve cases as settlement judges or actually as mediators. And I think it was successful, so much so that most of the mediation in the federal courts in the District of Maine are done by judicial officers now, which sort of cuts me out of the pie, but that's fine too. And I think that a different judge can bring insight and gravitas to a situation and help the parties reach a resolution. And I've seen this happen, and I'm very proud to watch now how my former colleagues are implementing this trend, and it's exciting to me. I think over the course of my judicial term, I presided over more settlement conferences and mediations than I did trials. And that may have been a coincidence, or it may have been a consequence of my peculiar deviant orientation. And the skills that I learned in the process were skills that I had developed in the course of my advocacy as an attorney, as a bankruptcy attorney and trial attorney, skills that I learned through on-the-job training and through some academic inquiry and some reading. And the skills that one must have as a mediator are the same skill set, whether one is a sitting judge or a private mediator or a retired judge. So I would like to, with your permission, talk a little bit about what those assets might be.
Please do. That's what we're here for.
Okay. I think a mediator should have several attributes. I'm not listing them in any priority, and my list is not necessarily complete, but I offer the following assets for contemplation. People skills. What are people skills? Pretty hard to define, but getting along and being able to read people is a very important skill for a mediator to have. Being empathic is another important skill. What do I mean by empathy? Empathy is the ability to comprehend what is troubling a party or counsel. Now, I say counsel specifically because it's not always parties. Sometimes lawyers get themselves in the jam and head towards mediation because they're hoping that a mediator might be able to not just adjust the situation between adverse parties, but modify the relationship between attorney and counsel so that attorney and client, so that the relationship may be more productive. Empathy is very important. Listening is very important. The ability to sit back and listen. I must tell you, I am a habitual interrupter, particularly when I was a judge. It's a very bad habit to have. It's not just impolite. It's not simply rude. It's also disruptive. So a mediator should train herself or himself to sit back and listen, not just hear, but listen and absorb and assimilate information. Legal knowledge is important. People think that a mediator should really have specific case-oriented legal knowledge, and surely that's helpful. But a competent attorney would know how to view a problem, know how to research the law, know how to read the law, and a competent mediator would ask the parties to provide the necessary statutes, rules, and case law to read in advance of the mediation for preparation. So legal knowledge in a specific area, if you're going to sit on a preference case, know the law of preferences for sure. But I would say that a competent attorney or a competent judge, unfamiliar with Section 547 of the code, might still be able to sit on a preference case with adequate preparation and a deep understanding of fundamental legal principles. Developing trust and confidence. How do you do that? That's pretty hard. You can't walk into a room and say, trust me. That's like walking by a restaurant with a neon sign that says good food. It's not necessarily the way to induce trust and confidence. So there's a certain presence that the mediator must exude that would instill confidence and instill trust and instill the notion that this is a person that will maintain confidentiality throughout the process. If the mediator loses the trust of the parties and the trust of the attorneys, very little is going to be accomplished. So maintaining trust and confidence is very important. There's also an understanding of the distinction between a position and an interest. People come into litigation with positions. A position is a conclusion of law based on fact, and it is advanced through advocacy. An interest is something very different. An interest may be economic, it may be emotional, it may be personal, it may be familiar. Everyone comes in to litigation, into court, and everyone comes in to a mediation with a bag of interests. The mediator has to understand the distinction between a position and an interest, and has to induce counsel and the parties to focus on interest as opposed to positions. As a mediator, both when I was a judge and now that I'm in private mediation, when people would pound on the table and say, I've got great claims, I have great defenses, this is my claim, this is my defense, and I'm going to defeat you, I suspend the proceedings and say, good, let's put this on a fast track. Go adjudicate it if your case is so good. But you're here not because your case is so great. You've already acknowledged that it's not perfect by entering this room. So let's get real, put our positions aside, and concentrate on our interests. Do these parties want to continue doing business after the fact? Do these family members want to continue in a loving, familiar relationship, or do they really want to have a divorce? Is there money to pay for a judgment? Okay, so understanding the distinction between a position and an interest, and training the parties before and during the mediation as to the distinction between a position and an interest is very necessary if there is to be success during the mediation. All of these things are necessary. Experience is important. Do I mean experience of just being a mediator, experience of being a judge, experience of being a litigator? Any and all of the above are important. But there are other sorts of experience that may be equally important. Does the mediator have athletic experience? Is the mediator a veteran? Is the mediator a mother or a father or a grandparent? All of these experiences enhance the ability of a mediator to read the situation. So we're looking for experience. If you add up all of these aspects and uh, try and come up with one word that might encompass them, what you're looking for is wisdom. Wisdom doesn't necessarily reside in an older person. There are young people that have wisdom, but wisdom doesn't just come from knowledge. It doesn't just come from experience. It comes from a combination of experience and knowledge and empathy and understanding and the ability to educate. The wise mediator will be able to explain, either in a plenary session or a private caucus, what the other side is all about in a way that might bring the parties closer together. That's a lot of information, but in my mind, that's what makes a good mediator.
Well, thank you. So apply that then to this. What is it? A little bit of a controversy out every now and then between private practice mediators using those or using judicial mediators.
All right. Um, a lot of that is based on perception, and that's understandable. Um, Lawyers perceive judges as being directive and evaluative because that's what they do in the course of their normal work. And they're sometimes shy of judicial mediators because they're worried that that a judicial mediator is a take charge sort of a person, and that that personality type may not fit the situation. There's also the notion that a judicial mediator might talk to her judicial colleague and tell the trial judge what's going on. There is also the notion that the parties, well, let's be more specific, the lawyers may have to appear before this mediation judge in another case, and they're wary of burning bridges. I can tell you, as a former judge and judicial mediator, that some of these fears are real some of the time with some judges, but most of them are not. Most judges are very competent and understand the nature of the process and are not going to violate the trust and confidence of parties in ways that people think. The other thing about a judicial mediator that we should appreciate is that, with respect to bankruptcy judges specifically, let me dwell on bankruptcy judges rather than the district court or the superior court. Bankruptcy judges, by and large, are selected by merit screening panels and referred for appointment to the Court of Appeals by merit screening panels, which means that by and large, bankruptcy judges have been vetted. And most merit screening panels are looking for the characteristics and attributes that I outlined as being applicable to a sound mediator, to a sound judge. So a judicial mediator has been vetted to a certain extent. Now, does this mean that a private mediator is unknown to the parties? Not at all. Private mediators have reputations. They may be interviewed. People may ascertain their skill sets. And private mediators who have been judges, like me, have also been vetted in that way. So being a judge doesn't necessarily mean that one has a better skill set. Being a judge doesn't necessarily mean that one is going to whisper in the ear of the trial judge. Um, all mediators, private mediators, and judicial mediators um, should be able to convey that they have the necessary skill set for parties. The important thing for parties to do is to select a mediator in the same way that they would select a lawyer or a surgeon, by reputation and by interview, and get a second opinion and interview 2 or 3. And if your opponent wants one mediator that is equal to the one that you want, don't fight over it. Go with your opponent's mediator. Maybe that's a way to break a deadlock. You see, when it comes to reconciliation, um, we have to maintain open minds, and to put people in boxes, the box of judicial mediator, the box of private mediator, is unfair to the process. It's unfair to the parties, and it's unfair to the potential mediator. Now, there are practical concerns. Let me dwell on those for a moment. Judicial mediators are free. Okay. We now do things by Zoom, and judicial mediators have for the last year been doing their hearings electronically. They have the right skill set. They have an IT department that can plug everything in. They are ready to go. And hopefully we'll be back in the courtroom soon. And they have chambers and they have conference rooms. Nobody has to pay for them. So there's a benefit, a very strong economic benefit to going with a judicial mediator. Now that I'm a private mediator, I must minimize that and say that that's not all important, but it does have importance, particularly in smaller cases. In small consumer cases, in small business cases, cost is a very real factor. Now, a word about private mediation. Private mediation is really not expensive when one considers that the cost of the mediator is going to be shared by parties. Now, in a two-party situation, that's half. In a multi-party situation, it might be a third, a fourth, a fifth. So the overall cost is not that great, particularly when you weigh it against the cost of litigation and the cost of a judicial outcome that is really not going to benefit the winner or the loser. So I would say that cost should not be an overriding concern, but if it is a concern in a small case, judicial mediation may be an option. I can tell you that during the last few months, I've been working with the Boston Bar Association in Boston and the Maine Volunteer Lawyers Project and Bankruptcy Court to come up with a way of providing pro bono mediation for needy people using COVID-19 as the entry point, if you will, that we all suspect that at some moment, hopefully it won't happen, but at some moment there's going to be a tidal wave of cases, and the courts may not be able to handle them, and mediation may be a way to mitigate the overflow of cases. So judicial mediation is cost effective, but private mediators serving in a pro bono capacity can provide the same service.
Okay, well, that's fascinating. So I suspect that you mentioned a tidal wave coming. Is there going to be a place where judges will say, I've got enough work, I'm not available to mediate?
I hope so. That's why I'm a private mediator.
Well, very good. Well, this is fascinating, most helpful, a lot of wisdom, and I really appreciate it. And we'll have to do this again sometime.
I would hope so. And Don, thank you for all that you do for your viewers and readers. I just want to say thank you.
Well, And with that, if I can find the off button here, we will sign off.